Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw, the one place to go to keep yourself updated with everything important that happened in India's courts today. The courts were as busy as ever and so were we. So, let's begin. The Supreme Court is set to decide a crucial question on reservation policy, whether the 50% ceiling for scheduled castes applies to colleges established under the Special Component Plan, or SCP. This follows a challenge to the Allahabad High Court's order, which had struck down a 70% SC reservation in 4 medical colleges of Uttar Pradesh. Holding it exceeded the constitutional ceiling. The SCP was launched in 1979 as a focused effort to promote educational advancement for SC students, particularly in areas like medical education. Under the plan, certain colleges are established exclusively to provide opportunities for SC students, often with full or nearly full reservation aimed at improving access for socially and economically disadvantaged groups. Advocates for the plan argue that it's a targeted intervention to address historical educational disparities. In the petition before the Supreme Court, lawyers contended that the 70% figure does not violate constitutional principles when considered in the context of the overall SC representation across all 44 medical colleges in the state. They highlighted that the effective SC admissions remain below the 50% ceiling when aggregated, and that the SCP is meant to create an equitable academic environment for students who otherwise face structural disadvantages. The case is being closely watched because its outcome could clarify how reservation limits under the Constitution interact with special educational initiatives like the SCP, potentially affecting similar schemes across the country and guiding future policy on affirmative action. Students at the National University of Juridical Sciences, Kolkata, are intensifying their protests demanding the resignation of Vice-Chancellor Professor Nirmal Kanti Chakraborty. This unrest follows serious allegations against the VC, including sexual harassment under the Prevention of Sexual Harassment Act, or POSH, and claims of financial impropriety. In 2024, a faculty member filed a POSH complaint against the VC, while the Calcutta High Court and the Supreme Court dismissed the complaint on the grounds of limitation. The Supreme Court directed that the VC include the dismissal order in his resume, stating it should haunt him forever. This directive has sparked widespread student demonstrations across the campus, with students expressing concerns over the administration's continued silence on the matter, which they believe undermines trust and accountability. Additionally, there are allegations of financial mismanagement within the university, further fueling the students' demands for the VC's resignation. In a dramatic turn in the Telangana phone tapping case, the state has informed the Supreme Court that former intelligence chief T. Prabhakar Rao, the main accused, allegedly destroyed critical digital evidence while under interim protection. According to the state, Rao formatted his iPhones and an official laptop on September 5, 2025, just days after being granted protection from arrest. Solicitor General Tushar Mehta argued that this act of destruction seriously compromises the investigation and amounts to tampering with evidence, raising questions about accountability and compliance with court directives. The Supreme Court is now being asked to cancel Rao's interim protection, with the state emphasizing that continued immunity could undermine the investigation's integrity. This case remains a crucial test of how courts balance interim protections with ensuring that ongoing investigations are not obstructed. The court's decision could have wider implications for handling high-profile cases involving digital evidence, and we'll keep following the case as it develops. Next up, Justice B.V. Nagratna has raised concerns over the increased number of bail matters being heard by the Supreme Court, observing that the Apex Court has effectively become a bail court. On Monday, she noted that the bench had heard 25 bail matters on Friday and 19 on Monday, stating, one after the other, we are considering either granting or refusing bail. This follows similar observations by other judges. In March 2024, where Justice B.R. Gawai noted that every Supreme Court bench hears at least 15 to 20 bail matters daily. Going further back in January 2023, Justice Sanjay Kishan Kaul observed that nearly a third of the cases in the Supreme Court were bail or remission cases and called for reforms to reduce the flow of bail matters straight to the Supreme Court. Justice Nagratna's comments highlight the growing concern regarding the Supreme Court's involvement in routine bail matters, which traditionally fall under the jurisdiction of the lower courts. The increasing workload may impact the court's ability to address other pressing constitutional and legal issues. This is just another indicative situation reflecting the need for judicial reforms to streamline the handling of bail applications and ensure that the Supreme Court can focus on its primary role, as the final arbiter on the significant legal matters. In a major update for filmgoers, the Karnataka High Court has stayed the state government's recent rule capping movie ticket prices at 200 rupees. The interim order issued by Justice Ravi Hosmani came in response to petitions filed by the Multiplex Association of India and other stakeholders who challenged the amendment to the Karnataka Cinemas Regulation Act. Senior advocate Mukul Rohatgi, representing the petitioners, argued that the amendment was arbitrary and lacked a clear rationale. He questioned the basis for imposing a uniform ticket price, stating if a customer wants to pay more for more luxury, there is no reasoning why with a broad brush it should be stopped. Rohatgi further highlighted that a similar government order in 2017 had been challenged and subsequently withdrawn, suggesting a pattern of overreach by the state. The petitioners contended that the Karnataka Cinemas Regulation Act does not grant the state authority to fix ticket prices, and such an amendment infringes upon the business rights of cinema operators. They emphasized that the rule affects numerous cinemas and disrupts their operations. The state government has been directed to respond to the petitions, and the matter is scheduled for further hearing. The interim stay provides temporary relief to cinema owners, allowing them to continue charging ticket prices as per their discretion until the court issues a final ruling. In a development that has left the Chandni Chowk shop owners concerned, the Supreme Court has ordered that sealing actions against unauthorized constructions in Chandni Chowk will resume with all existing stay orders expiring on December 31st, 2025. A bench of Justice Suryakant and Justice Koteshwar Singh flagged that the appellate tribunal under the MCD has been non-functional since its presiding officer's term ended, and directed the Delhi High Court Chief Justice to appoint a replacement. The court made it clear that stays protecting properties, especially residential premises converted into commercial use, will not survive after December 31st. Affected parties have the option to approach the tribunal once it's functional. The Municipal Corporation of Delhi has been tasked with implementing sealing orders, assisted by the Delhi Police for enforcement. Property owners argued their shops had been running for decades, but the court said longevity does not cure illegality. The MCD must now file a status report on whether properties were originally commercial or illegally converted later. Shifting our focus on some important clarifications regarding taxation law, as the Supreme Court has dismissed the Union of India's appeal against Adani Power Limited, affirming that the movement of goods from a domestic tariff area or DTA to a special economic zone, that is an SEZ, is considered a domestic supply and not an export outside India. Consequently, such transfers are exempt from the export duty under the Customs Act 1962. The Union government had argued that any movement from the DTA to an SEZ constitutes an export as per the Customs Act's definition, which includes taking out of India to a place outside India. However, the court upheld the Gujarat High Court's judgment, which relied on the Special Economic Zones Act 2005. The SEZ Act defines export within its framework to include supplies from the DTA to SEZ units, but this definition pertains to entitlements and benefits under the SEZ Act and does not extend to the levy of export duties under the Customs Act. The court's decision weighs in on the self-contained nature of the SEZ Act's legal framework, distinguishing between internal supply mechanisms and international export obligations. And finally, in a case that is symptomatic of the systemic delays that the legal framework is plagued with, the Punjab and Haryana High Court has criticized the Punjab police for an inordinate and unjustified 15-year delay in filing a cancellation report in a criminal case. The FIR, registered in 2007 under sections 323, 341, 506 and 34 of the Indian Penal Code, had been followed by a compromise between the parties in the same year. A cancellation report was prepared between 2007 and 2009 but was not filed until the intervention of the High Court. Justice Sumit Goyal expressed serious concerns over the lackadaisical approach of the investigation agency, stating that such inaction amounts to an abdication of statutory and constitutional duties. He emphasized that the failure to discharge this duty promptly undermines the faith of citizens in the efficacy and fairness of the justice system. The court imposed the cost of 1 lakh rupees on the Punjab government for the delay. The court noted that while the legislature has not prescribed a mandatory time limit for the presentation of a final report, the discretion afforded to the investigating agency is neither absolute nor unbridled. The court stressed that the authority to initiate and pursue prosecution is an inherent and an inalienable element of the sovereign power of the state, which must be exercised with utmost diligence and transparency to uphold the foundational principles of the rule of law. And with that, we finish with the day's edition of Courts Today by LiveLaw. For more detailed coverage on all the judgments and issues mentioned in the video, visit us on www.livelaw.in and follow us on Instagram and YouTube to stay updated on these issues and more. I'm Debojit Das. Thank you for watching.